Okay, are we all ready?
Yes, thank you.
Rise.
These are appeals in the matter of the King, the application of Oakley, and the Secretary of State for Justice.
Morning.
My ladies, my lord. I appear on behalf of the Secretary of State for Justice, and I'm leading Mr. Granson and Mr. Leary. And Mr. Jude Bunting is for both Sneddon and Oakley.
Yes.
But the juniors bifurcate. Mr. Bimler is for Mr. Sneddon, and Mr. Buckley is for Mr. Oakley.
Yes.
That's the representation. The bundling, I hope, has got to the court. There's a core bundle, a supplementary bundle, and a core bundle of authorities, and a supplementary bundle of authorities.
Yes.
Apologies for the volume.
Yep.
I suspect, particularly in relation to the bundle of authorities, there's a myriad of authorities pretty much addressing the same sort of question in slightly different ways. But
Yes.
they're included for what they're worth, and I'll try and narrow that down for the court if I may. The court will be aware that we are dealing with the power in the Secretary of State to transfer prisoners to open conditions that is conferred by Section 12(2) of the Prisons Act 1952. That provides, behind tab 1 of the authorities bundle, page 1 of the core authorities, prisoners shall be committed to such prisons as the Secretary of State may from time to time direct, and may by direction of the Secretary of State be removed during the term of their imprisonment from the prison in which they are confined to any other prison.
Yep.
So that's the basic power.
Yes.
That discretion, as is evident from its terms, is conferred by Parliament on the Secretary of State as the decision maker. There is no requirement for cases in which transfer from closed to open conditions is in issue. There is no requirement for a case to be considered by the Parole Board. But the legislation does make provision for the possibility of the Secretary of State deciding to refer a case to the Parole Board for advice. That power is contained in section 239, subsection 2 of the Criminal Justice Act. And if you go behind tab 4 of the authorities bundle, page 9 of the core authorities, you will see that the wording of that section, that subsection, provides it is the duty of the board to advise the Secretary of State with respect to any matter referred to it by him, which is to do with the early release or recall of prisoners. And as has been held in a number of cases, I'm going to come to Gilbert directly, but paragraph 7 of Gilbert, transfer to open conditions falls within that rubric. That's paragraph 7 of Gilbert.
Paragraph 7 of Gilbert.
Paragraph 7 of Gilbert per Lord Justice Sales. Maybe worth turning up Gilbert now. And I go to Gilbert right at the outset, because despite the plethora of first instance authority on the issues that confront the court, there is only, as far as I'm aware, one Court of Appeal decision.
Yes.
Which deals with this.
And that's Lord Justice Sales giving the main judgment in.
Exactly so, and that's in Gilbert. So if I could invite you to go to Gilbert, I'm going to start and not quite finish, but start with Gilbert. Tab 14 of the authorities bundle, page 363 in the core authorities. And the paragraph that I referred you to a minute ago in relation to the scope and reach of 239, you will see at paragraph 7 what is said by Lord Justice Sales, effectively giving the judgment of the court. If you flip forward to 394, you'll see that Lady Justice King and the Chancellor both agreed with his judgment. So paragraph 7, if you would, I wasn't proposing to read it out unless you'd like me to, but...
So transfer falls within early release.
Exactly. So, as he rightly pointed out, Lord Justice Sales, there are effectively two tiers of discretion in the Secretary of State. The Secretary of State is not obliged to refer, as Gilbert points out at paragraph 68. If you go forward to page 387, so far as concerns seeking advice from the board under 2392, it is a matter of discretion for the Secretary of State to do so or not. If the Secretary of State, underlined rationally, considers that the assistance which the board might be able to provide in a particular case is limited and not worth the additional expenditure, it's lawful for him to decline to refer the matter to the board for advice. So limb 1 of the discretion, do you refer, recognised in paragraph 68. And likewise, the Secretary of State is not obliged to, but has a discretion as to whether or not to accept a recommendation that is made if he does choose or she does choose to refer a case to the Parole Board for their advice. And as Lord Justice Sales points out in this judgment, and as numerous other cases have also pointed out, that stands in stark contrast to other provisions within this broad legislative scheme, including in particular section 28 of the Crime Sentences Act 1997, where there is an obligation to refer to the Parole Board and there's an obligation in effect to abide by the Parole Board's decision. So the Parole Board can direct the Secretary of State. So there is that very clear distinction within the legislative scheme. Some types of decisions, some types of cases have to go to the Parole Board and their decision is binding. Others do not have to. There's a discretion to refer and there's a discretion to accept their advice or not. And we submit that the correct approach in principle, if you're still on page 386 to 387, the correct approach in principle to the issues with which this court is concerned is in effect set out by the unanimous and, I would add, binding Court of Appeal decision in that case. Look, first of all, as the key first relevant section, to paragraphs 65 to 74 of Gilbert. And I just wanted to, I'm not going to read it all out, I just wanted to trace through the reasoning of the Court of Appeal in those paragraphs. And you will see from paragraph 65 that the analysis starts with a slightly different form of issue, but we respectfully submit the reasoning applies just as much into our context. That was to do with the absconder policy, as you see from paragraph 65. And the argument was that the absconder policy, in effect, undermined the statutory role of the board. And the reasons for that, as advanced by the claimant in that case, are summarised in paragraph 65 if you just cast an eye down that paragraph to show you the shape of the argument. So you'll see the argument was put in two slightly different ways. One of them was that the absconder policy would narrow the range of circumstances in which the Secretary of State might refer cases in relation to transfer to open conditions to the board. And the other way of putting it was to say when it comes back from the board, it might narrow the range of circumstances or broaden the range of circumstances in which the Secretary of State disagrees with that recommendation or that advice from the board. And so you will see that those were the twin ways in which the argument was being put. So you'll see that we're in the territory of this appeal, albeit in the context of a slightly differently formulated issue to do with the absconder policy. Just for your note, ROTL, as I'm sure you're all aware, in the fourth last line of para 65 means release on temporary licence. This is full of acronyms, but that's what that one means. And then if I could invite you to drop down to paragraph 68, if you would, dealing with the seeking of advice from the board under 2392, the conclusion of the Court of Appeal was, it is a matter of discretion for the Secretary of State to do so or not. if the Secretary of State rationally considers, and so on, it's lawful for him to decline to confer. That's paragraph 68. And he acknowledges that the effect might well be as the claimant indicates, but the conclusion is that that doesn't undermine the statutory scheme. It's just a product of the way in which the policy works in the context of a discretion, which has to be exercised rationally. So the legal standard is the very well established public law standard of rationality. 69 is the beginning of a separate strand of submissions based on the idea that it undermines the statutory scheme because, in effect, the parole board is an expert body in the context of this sort of consideration. That's the nature of the submission, as you see from paragraph 69, and you'll see what the court made of it at paragraph 70. Doesn't agree with it, no authority to support it. The discretion enjoyed by the Secretary of State in relation to seeking advice from the board under 2392 is to be contrasted with the obligation he has to refer cases to it periodically to consider applications for release on licence under section 28. Remember, that's the section in which I drew attention, contrasting the position with the discretions that exist in 2392 and on return to accept the recommendation or not. The 2003 Act, the court goes on in paragraph 74 or 5 lines down, 2003 Act confers a discretion on the Secretary of State whether to seek advice or not. The fact that it refers to advice rather than mandatory directions also underlines the discretion enjoyed by the Secretary of State in this regard. He is not bound to follow advice. Moreover, the Act does not even refer expressly to advice about transfer to open conditions, but only to advice about matters referred to the board by the Secretary of State with respect to any matter which is to do with the early release or recall of prisoners. That's the language of 2392, as you'll recall. The statute does not confer on the board any express function to advise on the question of transfer to open conditions, and that point is being made simply to emphasise the breadth of the discretion and therefore the lightness of the public law control which applies to it that is conferred by the legislation on the Secretary of State, both in relation to the discretion to refer and in relation to whether or not the Secretary of State chooses to accept the advice of the parole board on return if he does refer. And so that's the first part of the rejection of the expert body submission in paragraph 69. But there's another more functional reason for the rejection of that submission in paragraph 71. The Secretary of State and his department and its agencies are also experts in management of prisoners in the prisoner state, including assessing prisoner risk when it's relevant to a wide range of decisions which such management may provide. The statutory regime recognises this. They do not require input from the board for every decision they have to make, including those in relation to which prisoner risk may be a significant factor. If, in light of the Secretary of State's policy regarding transfer to open conditions, he does not consider it helpful to refer individual cases to the board for advice, that is lawful and doesn't deprive the board of any function which the statute contemplates it must fulfil, as distinct from a function which it might fulfil if the Secretary of State thinks it appropriate to do so. So that's the rejection in those two paragraphs, with the broader reasoning chiming into our context, as you see, paragraphs 70 and 71, important reasoning. 72, they turn to what they describe as the more far-reaching aspect of the claimant's argument under this ground, which was that in the case of every prisoner covered by the absconder policy, where the question of transfer to open conditions arises, the Secretary of State ought to be asking the board in general terms whether it would recommend such a transfer, and then ought to abide by such recommendation, at any rate, absent very good reason not to. You remember the chiming language from the judgment of Mr. Justice Fordham and Sneddon. But that's the submission that's effectively made, albeit in the context of this absconder policy, in paragraph 72. That also is rejected by the Court of Appeal. This submission, they say, paragraph 73, ignores the distribution of responsibility between the Secretary of State and the board as contemplated by the statute. The Secretary of State has the relevant discretion whether to transfer a prisoner to open conditions. He can therefore promulgate his own policy as to how that discretion should be exercised, and has done so, as far as relevant here by way of the absconder policy. He has the discretion whether to seek advice from the board, and even if he seeks its advice, he is not bound to follow that advice, provided there is sufficient good reason not to. C, and then he cites a judgment which I'll come to in a moment, the judgment of Mr. Justice Jackson, as he then was, in a case called Banfield, and you'll note the two paragraphs which are specifically singled out for praise in that paragraph, paragraphs 22 and 28 of Mr. Justice Jackson's decision in Banfield. The court goes on, the Secretary of State is not obliged to seek the advice of the board. Further, if the advice given by the board fails for whatever reason, take into account relevant policy governing transfer, that's likely to constitute a good reason, and so on. And then you'll see what is said in relation to the specific absconder policy in 74. Yep. So that's that reasoning we respectfully submit is very important for present purposes for obvious reasons. And the point about the Secretary of State being entitled to produce policy to provide guidance as to how he or she will exercise either of the two relevant discretions in effect is reconfirmed, as it were, under the when dealing with a slightly separate ground of appeal, which alleged there was an inconsistency with a prison service instruction. If you go to paragraph 82, I just wanted one sentence from paragraph 82 to confirm that point, which is the second sentence. As in Re Findlay makes clear, the Secretary of State is entitled to have a policy in relation to how he will exercise any discretion he has regarding the treatment of prisoners, and is entitled to change the policy from time to time, and then rejects the legitimate expectation argument that had been mounted. The final ground of relevance in Gilbert, just so we take it all at once.
Sorry, the policy here is what, GPPPF?
My lady, yes, it's
yes.
the 5.8.3.
Yeah. Okay, so that's what
I'm going to come and show you that in a second. I'm not a great player, but no one seems to be challenging the entitlement of the Secretary of State to have made that policy in accordance with these principles. So I'm taking that as read. There's a bit of a dissonance, as you will have seen potentially, between a policy that says unless there's jolly good countervailing reason or there's strong reason to transfer them to open conditions, don't, as it were, between that and the approach that appears to have developed through the line of case law that we're considering. But I'll come to that policy in a second. I wanted to take you to the irrationality ground of challenge in Gilbert, which starts with the title above paragraph 90 on page 393. And the relevant part of the irrationality challenge there is dealt with in paragraph 92, where the suggestion was made, as you see, that it was irrational for the Secretary of State to decline to accept the recommendation of the board that Mr. Gilbert be transferred to open conditions. I do not regard that as a sustainable contention, says Justice Sales. The Secretary of State is entitled not to accept such a recommendation, provided he acts rationally. Underlined, provided he acts rationally in doing so. C, and then you've seen already the two paragraphs he cited from Mr. Justice Jackson in Banfield. For good measure, he cites another authority there, a decision of Mr. Justice King in a case called Wilmot. And if you wanted to write next door to that, Banfield is in the core authorities, tab 8, page 72, and Wilmot is in the supplementary bundle of authorities, tab 7, page 105. I'll take you to both of those briefly in a moment. Going over the page to 394, in some cases where the parole board has reached a view on some point which is the same as a point which the Secretary of State has to consider, and the board is better placed to make an assessment, e.g., it finds a relevant fact after hearing oral evidence from witnesses, it might well be difficult for the Secretary of State to show that it's rational for him to take a different view, and then refers back to the PSI, that is not this case, and so on. So that is Gilbert. And just pull the strands together, if I may. You saw from paragraph 65 to 74 that the central emphasis of the court was on the Secretary of State being the statutory decision maker, with discretion to refer and discretion to accept or reject the advice given if there has been a reference. And the existence and breadth of that discretion and the statutory division of functions between the Secretary of State and the Parole Board in this context, i.e. our context, is highlighted by the contrast in other statutory provisions, section 28 of the Crime Sentences Act 1997, that are referred to in paragraph 70 of the Court's judgment. There is a clear acknowledgement by the Court of the expertise of the Secretary of State in relation to these matters, in other words, whether to accept the discretion, risk, management of prisoners within the prisoner state, and so on. And that is recognised as important in assessing what the right approach is in principle at paragraph 71. And importantly, the control in these circumstances is the standard public law control of rationality, emphasised both in paragraph 92 and in paragraph 68. I said I would take you briefly to Banfield and Wilmot. Can we go to Banfield first? That's in tab 8 of the core authorities bundle, page 72. Tab 8, page 72 of the core authorities. Mr. Justice Jackson, as you see.
7 parts. 7 parts.
I was about to say a pretty well-known taxonomy from Mr. Justice Jackson, beginning of the judgment, which was then ruthlessly followed as the logic unflows.
Yes.
But the bit that we want within that well-acknowledged and strict logic starts with a section dealing with the law, the title above paragraph 20 on page 81. Mm-hmm. And you'll recall that the two key paragraphs that are cited and relied upon and indeed approved, so we would say incorporated in effect by reference into the binding reasoning of the Court of Appeal in Gilbert, are 22 and 28. And so you will, in effect, see that this has the stamp from the Court of Appeal. 22 sets out 239 sub 2, which we've seen. And that final sentence is perhaps of interest. The advice which the Parole Board gives on this matter is not binding upon the Secretary of State, but it's obviously an important factor. It's a factor in his decision. So final sentence of paragraph 22. It's a factor. And then paragraph 28, setting out the 5 principles, 7 parts of the analysis that Mr. Justice Jackson produced. Can I invite you particularly to read 1, 2 and 5 for our purposes, but by all means skim 3 and 4 as well. So you'll see in particular that the first one, first of those factors, again the final sentence of the first subparagraph in 28, nevertheless it is a matter for the Secretary of State what weight he assigns to those factors in any given case. And that those factors are the recommendation of the Parole Board and its expertise. He's characterising those matters as matters of weight. that are, again, on absolutely bog standard public law principles, weight is a matter for the primary decision maker. 2, 3 and 4 are to do with the fairness or otherwise of the process, and then back to the substance of the decision in 5, even if the decision is fairly taken, if his final decision is irrational, it may still be quashed on traditional Wednesbury grounds. So that, we respectfully submit, is all part of a piece with the logic and reasoning of the Court of Appeal in Gilbert, and not merely echoing and all part of a piece in a broad and general sense, but specifically approved and incorporated, as it were, by reference into the judgment of the Court of Appeal in Gilbert. So that is Banfield. Wilmot, I'm afraid we have to go to the other authorities bundle, and it's tab 7 of that other authorities bundle. So it's tab 7 of the supplementary authorities, page 105. I think in a subsequent case when Heather Williams was still a QC sitting as a deputy, she said, Mr. Justice King as he then was, and I couldn't, I'm afraid, remember whether Mr. Justice King had in fact been elevated to these great heights.
No, maybe it's reference to retirement.
They may have got confused with Lady Justice King, perhaps, sitting as part of the court in Gilbert. But Mr. Justice King in Wilmot, and you'll remember that the relevant paragraphs cited by Lord Justice Sales in Gilbert started at 43, and you'll see the title above paragraph 43 on page 119, status of any parole board recommendation.
So paragraph 45,
Yeah.
when you want, and there's nothing more, is there, from
Well,
this?
my lady, there is 45 public law principles, exactly, that summarises the essence of it. Then the last bit of paragraph 46, perhaps, Secretary of State would be acting unlawfully if he didn't take such recommendation into account. That's the kind of factorial approach that you saw reflected in Mr. Justice Jackson's judgment and then the Court of Appeal in Gilbert. And then 47, the reference in about 5 lines down to the application of public law constraints, again suggesting it's bog standard public law constraints. Hence, to date, the guiding principles in the authority, I'm reading from halfway down 47, has been that it's not for the court itself to assess the reasonableness of the parole board to determine whether it can characterise the action in the Wednesbury sense. The court must rather direct its attention to the rationality of the Secretary of State's decision, will not interfere with that decision unless his decision is to be adjudged irrational in the Wednesbury sense or reached by unfair process. See Banfield, Mr. Justice Jackson, and we would add see now Gilbert adopting both of those. So that's an important and salutary point of principle in 47. You don't, in effect, treat the Secretary of State as though he was an appeal court sitting in judgment on the wisdom or otherwise of the parole board recommendation, nor do you test whether the parole board effectively got it right or wrong. What matters is whether or not the Secretary of State's decision was a rational one. And the test to be applied is one in which the parole board and its expertise and its recommendation are simply factors to be taken into account, important ones no doubt. But it is ultimately for the Secretary of State under the statutory scheme to make that decision. Does he accept it or does he reject it? And the control on that is proper public law irrationality. So you will have noticed that there is no hint in any of these authorities of the sort of thinking that one sees in some of the later authority of trying to ascribe through incredibly complex analyses of different subject matter areas, whether someone is a bit more expert than someone else, whether the Secretary of State carries the greater weight of expertise as compared to the parole board or otherwise. This is the orthodoxy, I respectfully submit. And it's these two authorities and the approach that they set out.
Going back to Gilbert, did Gilbert refer to Hindawi? Was the court in Gilbert taken to Hindawi?
I'm not sure I know the answer to that. There's certainly reference, do you remember, in the example that was given in paragraph 92 by Lord Justice Sales of disagreeing when there's an issue of credibility. Let me check. don't even know whether Gilbert has been reported, but I'm assuming not if it's in this form. Hasn't it? No, it hasn't been, so we don't know.
I don't think Hindawi features in it.
No.
No.
But you'll remember the paragraph 92 reference to witnesses of fact, and
Yes,
a
yes.
paradigm example of that credibility of witnesses that they've seen you haven't.
Thank you.
Some of the issues that are raised by the respondent, I'll refer for this purpose, can be seen in the judgment of Lord Justice Thomas, as he then was in Hindawi. But it was a decision of the divisional court. Obviously.
It was a decision of the divisional court, and in truth, when you get to Hindawi, as you will recall, the critical feature had very strong echoes of the example given by Lord Justice Sells at paragraph 92, because the particular issue that was central in Hindawi, if I recall it correctly, was whether or not the witness of fact, I think it was the prisoner, was in fact credible. So it was perhaps the paradigm example of the sort of case where if you were sitting as an appeal court, no, that's not the right analysis, but if you were, that would be the paradigm example of where you would give the greatest possible respect to the court at first instance, as it were. But it's that example right at the far end of that scale. But as you know, the analysis of the later courts has drifted into risk assessment and all the other things that are to do. If you believe Mr. Justice Fordham, it's pretty much anything the Parole Board does as part of its decision making. But that is a very tight example in relation to which, as Lord Justice Sells acknowledged, it might be difficult, and he put it no higher than that, to justify the rationality of the decision. I don't seek to
Would you
suggest.
say that it all depends on the circumstances?
My lady, yes, as long as one's a bit
The
careful.
language of Lord Justice Sales, as he then was, is contingent even in relation to that, might.
Yes, I think no one really minds that formulation. It obviously has a principled attraction because it allows facts to fluctuate and you don't close the door. But the debate before you is in truth about the narrowness or breadth of those circumstances. So it isn't just by, if one goes with that phrase, it isn't all circumstances. The real question is, in what circumstances might it be irrational for the Secretary of State to disagree with the recommendation or to take a different view more accurately? So just a little bit of caution in relation to that. I said I would refer briefly, and I'm only going to refer briefly to them, to the directions and policy, and I can probably do that by reference to our skeleton just to draw your attention to them. You'll recall that they were referred to by Lord Justice Sells in Gilbert at paragraph 73 something. And you have some directions being given to the parole board as to the matters that are to be taken into account when thinking about giving its advice.
That's paragraph 7 of your skeleton.
Exactly so, and I haven't got much to add. I'm hoping, so those are the directions, but I'm not sure that any of those are central for present purposes. But more importantly, perhaps, as Lord Justice Sells noted at paragraph 73 of Gilbert, there is also an entitlement in the Secretary of State to make his or her own policy as to how the relevant discretion to reject or not agree with a parole board recommendation will be exercised, and that's the stuff of paragraph 8.
Why does 5.8.2 refer to the PPCS and 5.8.3 refer to the Secretary of State?
Pass. Can I check that? I'm not sure what the answer is.
No, it may not matter.
I'm not sure it does, but I will check and see if we can find an answer. But perhaps the two things to note about that policy. It was the policy at the time, and it is perhaps to be noted that the formulation of that policy and the circumstances in which disagreement with parole board recommendations will or may occur has changed over time. If you just go, if you would, I'm just going to show you this and do not much more than that, but if you go to the supplemental bundle of authorities, tab 34, you will see that you have there an early iteration of the relevant policy on disagreement. And if you look particularly at paragraph 6.4 on page 637, do you have that?
Yes.
Just look at the bit before the bullets. The parameters for rejecting the parole board recommendation for transfer are very limited. Criteria for rejection of the panel's recommendation either, etc., etc. And then you see the reference, even in this version, to the Secretary of State may also reject where he doesn't consider there's a wholly persuasive case. That was the policy at the relevant time, but it's in this early iteration. And just cast an eye to the very bottom right-hand corner of page 637, you'll see the issue date for that one, which is the 25th of June 2015.
Nobody's spent much time, and there may be no need to, but what does wholly persuasive mean? I think one of the authorities says it's common sense language, and I'm sure that's right, but it's an interesting phrase, isn't it?
My lady, it is. Perhaps the legal interest of it is that it posits a test which, as it were, places the ball squarely in the Secretary of State's court.
It's a
To kind of read-
subjective
Yeah, to kind of redecide whether it's is
Am
a
I
strong case for
persuaded?
doing
Is
it.
it
It's
persuasive?
yeah, it's almost a tilt in favour of or towards the public interest in protection, as it were.
I think my lady's thinking of the judgment of Mrs. Justice Andrews as she then was in
That's
Queen
right.
Mosque.
Yeah.
Thank you
Yeah,
very much indeed.
I'm very grateful to my learned friend for that. That's
but-
right. But just to show you how it develops, as it were, just so you
Sorry,
have
so wholly persuasive, what do you say? Insofar as it may assist, you say it tilts towards public safety.
it tilts towards public safety on one view because you're not, as it were, starting with the parole board being presumptively correct. You're starting with a judgment call for the Secretary of State as to whether or not there's a wholly persuasive case for transferring the prisoners to open. But no one suggested that the policy is, in that respect, unlawful or contrary to the Supreme Court judgment in the A case as representing a misdirection of law. Just so you see how it develops, again, if you flick to the next tab, page 6, I think it's 3.9, the lines have gone straight through my numbering, but it's the next tab is the next iteration, as one sees from the date at the very bottom of the page, issue date 27th of Jan.
Sorry, my fault, I'm behind. Next tab.
Next tab, tab 35.
Thank you.
Bottom of the page, look at the issue date, 5 years later, is 27th of Jan 2020. And you'll see 5.82 and 5.83 being set out in that one. Go to the next tab, page 644, and you see pretty much the same approach. This version is the 13th of May 2021.
The relevant one, because this is the one in force when the decisions, the parole board decisions were made.
The next tab is,
Next
but
tab
it's
is-
in identical form. That was the one that was issued.
You don't look to the policy as at the date of the Secretary of State's decision, is that right?
I think that's right. You look at it.
You look at the date the parole board made its
Yeah,
recommendation.
but for present purposes, it may not make much difference because they're pretty much the same as one sees from the dates on which there were changes.
Except we've got the root and branch review, haven't we, very shortly after the next one? Or in between.
I'm not sure
Yeah,
that.
the root and branch review is 2022.
Yes, and that led to the one in July 2022, which is behind tab 38.
Okay.
So the one I think that was in force at the relevant time is behind tab 37, page 644. But you've seen the form of it, in effect, in the earlier iterations since January 2020. Look at paragraphs 5.82 and 5.83.
Okay.
I think the root and branch review may have led to the version of the 21st of July 2022 behind tab 38.
That's right.
And you'll see that 5.82 and 5.83.
That's it, that's the change. But
Yeah,
the relevant
and
one, it's
exactly.
common ground, the relevant one for us is the one at tab 37.
I think so.
So if we started engaging in an analysis of what wholly persuasive meant, we'd be engaging in an entirely historical exercise, because it doesn't apply anymore.
You would for prisoners as of now and in the
Yeah.
future. My lord, you're right. You're right, but I don't think anyone suggests the court or invites the court to go down that route. The only significance that we respectfully attach to the form as it was and the form as it is now, as it were, is certainly in relation to the form as it was, there appears to be posed as a matter of policy for the Secretary of State by way of self-guidance, a pretty much open-ended question based on wholly persuasive, rather than saying, oh well, go back to the parole board and only disagree with it if there's stunningly good reason in all these different respects. That, I think, is the only significance. But again, that's only peripherally relevant, if at all, because no one is challenging the policy as unlawful in itself.
I think Jan's
Actually, I'm wrong, aren't I?
I think
Because
yes, wholly,
it reappeared in
wholly procedure is
2023.
back in, see page 654. But
Yeah,
654. 654.
yeah.
But we still don't invite my lord to
No,
opine.
no, well, I don't think we are.
Does the language of 5.8.2 have, can be traced back to what was said by Lord Justice Sales in Gilbert with the use of the word sufficient, which I think was a word he used in the context of the relevant test.
Yes, although Mr. Justice Jackson was 5.82 of the relevant policy at the time.
Looking at what's at tab 37.
37. Sorry, maybe I'm a bit behind. I'll put them away. Yes, my lady, I'm sorry. The question was, is that reflective of Gilbert?
Yes,
5.82.
yes.
My submission is that it's at least on one view narrower than Gilbert if you looked at 5.82 in isolation, because the basic theme of Gilbert is the Secretary of State's entitled, particularly having regard to his or her expertise and the division of functions, to disagree on any rational basis. This is
But taking into account the policy, the question, again, as I understood it, you would say is the decision of the Secretary of State that the parole board recommendation was not wholly persuasive.
yes,
irrational.
5.83.
That's the question.
Yeah.
That's the decision that the Secretary of State is making in line with his or her policy. I do not consider that the parole board recommendation is wholly persuasive, and therefore I am entitled to and do reject it.
My lady, yes, sorry, I was focusing on
No,
5.82.
you were quite right in
rather-
answering my lady's question, but just
Yes.
for my own benefit.
Yes.
In terms of thinking, you accept that the policy has to be, as it were, respected by
Yes.
the Secretary of State.
Can be
And therefore,
departed
it's
from
not
an
an
exceptional
open-ended, an entirely open-ended discretion. The decision has to be in line with the policy. The decision has to be, I consider there's not a wholly persuasive case, and that's a rational decision, you say, on the facts of each of these cases. But there's
Exactly.
that gloss in the middle. It's not just, was it a reasonable decision? The decision is the one that it's not wholly persuasive.
Exactly so. To the extent that policy of this kind guides, of course, as with all policy in public law,
You've got to respect it.
you've got to respect it, particularly if it's a policy of this ilk.
Yes.
You've got to respect it, but you're not formally bound by it, as it were, if you decide that exceptional circumstances require a different view. But subject to that, I agree with my lady.
But so do you agree that the Secretary of State could not lawfully reject a parole board recommendation if they found there was a wholly persuasive case, but for some other reason
I do.
decided to reject it? You do.
I do. Unless they then went on and said, but for this wholly exceptional reason, I'm going to depart from the policy. But yes,
Something
in
like
principle,
that.
I agree.
Yeah.
Yeah. Ladies, my lord, I've sufficiently covered, I think, the expertise of the Secretary of State. You'll recall Gilbert.
Just before we put it away, I'm sorry to interrupt.
Yeah.
I am interested in this. Is it just a sort of glitch? PPCS and 5.82.
I'm not sure why.
I just don't
Would
understand
you,
that.
can I turn my back for a moment?
Yes, is
because
there
I'm
any help
more
in that while we're looking at it? Oh. could the Secretary of State reject under the 5.8.2 as well? Is it covered yet? Yes, it does.
Because I'm in the Secretary of State.
Okay.
It only acts through its official.
Yeah.
I'm told that the PPCS are acting under delegated authority with the Secretary of State then, I think, sitting on top of them, making a decision.
So nobody's taking a point on it.
No.
It may be, and my lord suggests it may be that 5.8.2 came first. I don't know.
And then 8.3 was tacked on.
It was tagged on, but is it? I'm treating it as common ground that you could replace Secretary of State for PPCS.
Well, I think that must be right,
5.82.
not least because 5.8.3 says also.
Yeah.
Yes, yes,
Yeah.
yeah.
Yeah, I think that's right. But we're the one that needs to get into the
Well,
weeds.
in real life, the Secretary of State,
Won't him or herself make every decision?
or indeed any of them probably,
Yeah, right,
with very rare exceptions.
right.
Thank you.
I'm grateful. Expertise, Gilbert, paragraph 71, citation of Mr. Justice Jackson in Banfield. You recognised. I wanted to take you to a slightly more recent authority on the same or a similar point, without seeking to gild the lily overly. Mr. Justice Eyre, in the Overton case, if you go to tab 21 of the core, so back into the other authorities bundle.
Are we going to get much from first instance decisions on this sort of point?
Well, you may not do. I was simply going to refer you
All right. What does Mr. Justice Eyre say?
briefly. I won't read these paragraphs out. The key bits are 25,
Sorry,
tab 21,
Thank you.
page,
Overton, yes.
page 513. You see the title, The Law, 2/3 of the way down, page 513.
It's a paragraph 27 or something, is it?
It's paragraph 27.
Yeah.
And you'll see what is said by Mr. Justice Eyre at paragraph 28, about halfway down that paragraph. There's a line beginning, there will rarely, if ever, be a single unquestionably correct answer. And then he sets out what rationality in effect involves. Two different answers can't be irrational if they're reasonable, if you see what I mean. But again,
That was
citing
paragraph, which paragraph?
paragraph 28, halfway down, there's a line beginning, there will rarely, if ever, be a single unquestionably correct answer. You see that four or five lines up from the bottom of page 514. We just read on from there. It follows that. That's what Mr. Justice Eyre takes from Mr. Justice King in Wilmot.
Well, all of this was quoted in its entirety by the judge in Oakley, one of the decisions we're having to consider.
It was.
I mean,
So
he
it's,
said this is exactly what I would have said, but it's been said for me.
Yeah, exactly. And it goes on to the end of 30 if you want it.
Yeah.
Can I make make submissions under 5 brief heads, if I may? I've seen that position in relation to the authorities. The first, this is really addressing the issue, is the parole board better placed, the correct principle approach? That's what the issue I'm on. So the first proposition is that the correct approach starts with the clear acknowledgement of the nature of the statutory scheme and the distribution of responsibilities it sets up. All of that's considered with great care by the Court of Appeal in Gilbert, Mr. Justice Jackson, Mr. Justice King, which they approved. Secretary of State is the primary decision maker. He or she does not have to go to the parole board, and indeed can by policy shrink down when they will go. Remember the absconder policy in Gilbert. And if they do go, they remain free to take a different view. So the appropriate public law standard is, under that statutory scheme, is rationality. And indeed, it might be thought that since the Secretary of State is not even required to go to the parole board, it's perhaps unsurprising that traditional reasonableness or rationality is in fact the test for disagreeing if he chooses to go and they come back with a recommendation or some advice. Note in particular, flowing from that statutory scheme, that the weight of factors, the weight to be ascribed to factors, is a matter for the Secretary of State. And you'll remember how Mr. Justice Jackson dealt with that in paragraph 28, summarising the propositions and describing in effect the expertise of the Parole Board and indeed their recommendation as being factors. The weight of factors is for him. That is so was also confirmed, if that's the right way of putting it. I'll give you one reference without inviting you to turn it up. Mrs. Justice Andrews, as she then was, in Kumar, K-U-M-A-R, at paragraph 54, on the weight of factors being for him. That's authorities, core authorities, tab 16, page 423. And of course, under that statutory scheme, there are no mandatory relevant statutory considerations. The discretion to disagree with the recommendation of the Parole Board if the choice is made to go is untrammelled in that respect. And moreover, the Secretary of State is well placed through the expertise that he or she wields in the management of the prisoner's state and indeed in assessing the risks that prisoners pose when managed in that estate. And one of the core concerns about Mr. Justice Fordham's judgment in Sneddon, rightly recognised, we say, in Oakley too, is that that expertise was not, in truth, acknowledged at all.
Would you say that that fits in with the position, which is that the Secretary of State is not obliged on this issue to go to the Parole Board at all?
Yes, because the statutory judgment is you don't even need to bother if you don't want to. I mean,
Rationally.
yes, but I was going to add rationally,
Yep.
but jolly difficult to see how a rationality challenge to a decision not to go might be mounted. I suppose you could say this is such a complicated case, it would be irrational not to go and get to the advice. Subject to that, I would agree with that. So the statutory scheme is the starting point with those things attached to it, as it were. The second, perhaps they shade into each other, these points, some of them, but the second is that the control is rationality. So the question is, if one leaves aside the middle ground of the policy, the question is, could a rational person, could a rational Secretary of State reach a different view on the question whether it's appropriate to transfer the prisoner to open conditions? That's the question. Rationality is the approach in Gilbert. True it is that there's that fleeting reference to an example of the Hindawi kind in paragraph 92 of the Justice Earl's judgment in Gilbert. But nevertheless, rationality is the approach. That's being put as an example of when the Secretary of State might find it difficult, not impossible, but difficult, to justify a rational disagreement. And Hindawi is a paradigm example. I don't seek to say that Hindawi on the facts was wrongly decided. It was plainly rightly decided, it might be thought, because of the centrality to the decision of the assessment of credibility of the prime witness, namely the prisoner. And the Secretary of State hadn't seen the prisoner giving evidence and the Parole Board had. But if two views are possible, back to that, then that is not irrationality. The definition of rationality is that it's possible to have two different but rational views. And the same point was made by Mr. Justice Jackson in Banfield at paragraph 44 of Banfield. So the control is rationality. Third point, the Secretary of State must consider and take account of the recommendation and views of the Parole Board. But that is because, having sought their advice, having exercised the discretion to seek their advice, those views are relevant to be taken into account. But they are, as the court found in the passages approved in Gilbert, they are factors. And the expertise and advantage of the Parole Board, which of course exists, but it shouldn't be overestimated or generalised, not least because the Secretary of State is very well placed to make very many of the judgment calls and assessments, including the overarching rationality question I've identified. Is it appropriate to transfer the prisoner to openness and overcomplicate it? But the weight to be accorded to those matters is ultimately, and pursuant to standard public law approach to rationality, the weight to the various factors is a matter for the Secretary of State. And of course, if that approach is followed, and that is the approach of the Court of Appeal in Gilbert, applying the earlier authorities that they cited, that is very, very different from treating the Parole Board recommendation and or aspects of the reasoning of the Parole Board as in effect binding or presumptively binding. The Secretary of State is not acting in some form of quasi-appellate role where he or she has to consider and decide whether the Parole Board was wrong or whether strands of its reasoning were in some way in error. The Secretary of State's duty in public law under this statutory scheme is to consider and ascribe weight to the various factors in play, including that recommendation, and to reach a substantively rational view on the overall question I just posed. That leads to the fourth point, which is that there is real concern, I respectfully submit, if you end up in a position that we appear to have ended up in now, which is that there's been a, as it were, a build-up of complicated rules or principles based on whether or not the Parole Board or the Secretary of State are better placed to make assessments about the risks undermining that are in play, or the various strands of decision making, or witnesses who might have given evidence to the Parole Board on a particular topic like diagnosis. I mean, once you start getting into that sort of judgment call as being essential to the correct approach in principle, I respectfully submit that not merely have you moved a very long way indeed from the correct orthodoxy set out in Gilbert and the earlier cases, but you've created an enormous and unattractive rod for your own back, as it were, because you've got a position now which requires, in effect, courts to ask philosophical questions about who's got the greater expertise, who's better placed. It's an extraordinarily complicated and over-intricate approach to what I respectfully submit on the orthodoxy should be a straightforward and simple question. Could a rational Secretary of State reach a different view on the basis of the material considered and for the reasons given? Could a rational Secretary of State conclude it wasn't appropriate to transfer this particular prisoner to open? So the concern is both with overcomplication as a result of going down this rabbit hole in the subsequent case law, but also, more importantly perhaps, because if you do go there and you end up in the place in which some of the case law has ended up, you do significantly undercut the correct approach with all its rigour and orthodoxy that was set out by the Court of Appeal in Gilbert. And you end up in effect with not a traditional judicial review on traditional Wednesday unreasonableness grounds or irrationality grounds. You end up with a decision in which you have drifted very close. See Mr. Justice Fordham's judgment as an example. You have drifted very close to almost everything the Parole Board does being presumptively binding in effect, and the Secretary of State then being held over the fire in circumstances in which he or she has not acted in some form of quasi-appellate role. And fifthly, therefore, we do not seek to gainsay the idea that there may be limited circumstances in which the Secretary of State might find it, I take the word deliberately from Lord Justice Sayles, para 92, might find it difficult to justify the rationality of that disagreement. And the classic example is the example that I've referred to on a couple of occasions, and indeed the one that Lord Justice Sayles gives, which is in effect Lord Justice Thomas and Mrs. Justice Nicola Davis, as she then was, in the Divisional Court in Indarwi. The finding of a relevant fact after hearing witnesses on which the issue of credibility was an issue. I may also say that I respectfully acknowledge the idea that some form of rigid classification of a distinction between fact and assessment of risk may well not be helpful in this context. My respectful submission is that it's not helpful because the moment you get into arguing about and thinking about that distinction, you are too far from the orthodoxy of Gilbert. I mean, it may well be that there are distinctions between issues relating to risks posed in the management of prisoners in the prisoner state and assessment of the risk that a prisoner poses on the one hand and on as compared to issues of fact. But it's very, very difficult to see how those actually work in practice to help a court determine whether the decision to disagree with the parole board recommendation is a rational one. So we respectfully submit that's the wrong question. It's a categorisation error, if you will, to go down that road. And of course the parole board will hear witnesses in a large number of these cases. Of course the parole board will consider the material with care. That's why their advice is being sought. And of course they will then produce their recommendation. But all of those matters simply lead to the public law requirement to take that into account. They do not lead to a presumptively binding conclusion. Still less do they lead to the conclusion that one ought to put the Secretary of State into a quasi-appellate position where he has to produce good reason for each of the strands of reasoning that the parole board found if he's going to reach a rational conclusion on disagreement or not. So my submission is that there will be very, very few findings where it might be difficult if the Secretary of State rationally disagreed with core reasoning of the parole board, Indarwi being perhaps the best example of that. And it may well be that that category of cases is indeed restricted to the category of cases which were described, I think, by the court in Oakley number 2 by reference to the famous Viscount Sumner description of when an estimate of the man is important for the purpose of the determination of the question of fact. In other words, where credibility is an issue. But the weighing of factors are ultimately for the Secretary of State, I respectfully submit. I wanted to deal with the Evans line of authority,
Yes,
if I may.
that'd be helpful, thank you.
And my short
Does that
submission...
include, sorry, does that include the power gen cases?
Yeah,
It does?
yeah. It's Powergen, Bradley,
Yeah, deny.
Deny, exactly. It's all that line of cases. And indeed the decision of Mr. Justice Kenneth Parker in the decision I'll come to, Gallagher. My submission is that that does not provide authority or even useful guidance into our context. Whether or not, and if so, that line of authority is applicable is fundamentally dependent on the statutory context you are considering. You can't simply transpose that approach based on the fact that you're dealing with a body which, for good and obvious reason, not least Article 5.4 of the European Convention on Human Rights, is described properly as a court, namely the Parole Board. That fact does not lead to the application of Evans without more. And the essence of the statutory scheme that we are considering, I have been through and was thoroughly emphasised by the Court of Appeal in Gilbert, which is that the court, that is the Parole Board, is here operating not in a determinative capacity, but in contradistinction to other parts of the legislative regime.
But is the parole board a court? I mean, a court surely has a decision-making function, and do you say parole board is a court?
Well, my lady, one perhaps doesn't need to grapple with that question, because I totally agree that the key feature is that it is here being asked for and is giving, under the statutory scheme, advice.
Yep.
I meant in its setup and its independence. There's been plenty of case law suggesting that it is a judicial body, but a judicial body can be acting in either a determinative capacity and or in the context of our statutory scheme, where it's simply asked to give advice to the Secretary of State. And one might have thought that it's in really no different a position under that statutory scheme in relation to that function, that specific legislatively ascribed function. It's in no different a position to lots of other situations in which Secretaries of State across the piece go to thoroughly expert people and or bodies to get advice. They don't have to then do more than take that into account and reach their own view on a rational basis. They're not bound in to producing good reasons or challenging the approach or reasoning of the parole board. I respectfully submit that that's the wrong question, but I agree with my lady that the key feature here is that they're simply giving advice. But that the application of Evans in general terms is dependent upon the statutory context is clear. And it is evident from, for example, cases in a very different context, like Gallagher. That's the Mr. Justice Kenneth Parker one that I referred you to. I don't invite you to take it up now. If I can just refer you to two paragraphs. It's in Supplementary Authorities, tab 5, page 72. And the key paragraphs for present purposes are 24 to 26, where effectively the argument was, well, here's an authority in which reliance was placed on Bradley, and the Kenneth Parker J decision was all about local authorities and someone who is roughly equivalent position, the Parliamentary Commissioner and Bradley. But Mr. Justice Kenneth Parker concluded, no, it all depends on the statutory scheme, and this one's very different. So you can't simply transpose Bradley. I cite that as an example of a court testing the breadth of the proposition by reference to the nature in detail of the legislative regime which confronts them. So although there are cases in different contexts, very often, like Evans, in circumstances in which, Evans, to take that as an example, you'll be very well aware of that, that was the King's handwriting case, giving advice to ministers and all of that, which went to the Supreme Court. And it was all about the Attorney General having a power of veto under the Freedom of Information Act, as you'll recall. But there, under that statutory regime, the Attorney General had a power to veto, as I recall, on reasonable grounds. That was the statutory language. So not even necessarily straightforward public law irrationality, but on reasonable grounds. But the power to veto or disagree on that basis was with the determination, the actual decision of a court. In that case, the upper tribunal, presided over by a High Court judge, it turns out. But it all depended upon the statutory regime in question, and there the function of the underlying body was a determinative rather than an advisory one, which makes, I respectfully submit, all the difference. And again, Power Gen, denied Bradley. They're all sitting in their own specific context. I wanted to take you to one authority in which the court had the pleasure of Mr. Bunting running the Evans argument.
This is Mr. Justice Dove, is it? This is Mr. Justice Dove?
That's Mr. Justice Dove in Harris.
Right, yes.
Yeah. So that is core authorities, tab 12. Tab 12 of the core, page 272 it starts, and the relevant paragraphs for present purposes are paragraphs 36 through to the end of paragraph 41, page 283 to 284. see the nature of the argument that Mr. Bunting was running, 36, 37, 38, Deny, Powergen, Bradley, Evans. And you'll see the disposition and the determination against, I'm afraid, Mr. Bunting on this argument in paragraphs 40 and 41. And essentially, in a sentence, if I'm allowed to do the judge that disservice, it all depends on the statutory scheme, and our statutory scheme does not lead to the application of that line of case law. So we respectfully invite the court to conclude that Mr. Justice Dove in that case was correct to reject this argument for the reasons that he gave. So can I briefly come to the conclusions on principle in the two cases that are before the court? And then I'm going to have a brief section on the facts of those cases, and it will be brief, not least because one of the cases has become a bit academic on the facts, but it stands as an example, as it were, of approach. So it may have,
That's Mr. Oakley.
that is Mr.
Sneddon.
Mr. Sneddon's out.
Sneddon, the Secretary of State.
Yeah, that's right.
Consternation at the time, but that's what happened. But I was going to go on conclusions on the principles in the two cases, and I start with Oakley. So we're dealing here with Oakley number 2,
Yes.
and that is in the core bundle itself, and it's at tab 28 of the core bundle itself. The decision is on the Judge Keyser. Sitting as the Judge of the High Court. Page C285. Do you have that?
Yes.
That's a relevant judgment. So that's the one we're dealing with, and I respectfully submit that he was essentially correct in his reasoning. He correctly identified that the particular advantage or not, it may not be of overwhelming importance. I put the matter rather more fundamentally and radically based on Gilbert than perhaps even the judge did in this case. We do query whether even searching for subject matter areas within the parole board's decision and then trying to assess whether they're better placed or not is flawed as an approach in principle and is inconsistent with Gilbert.
So which paragraph?
Paragraph 17 is the one I
Yes.
was really focusing on.
It's a very detailed, big paragraph.
Yeah. But it is quite important if you're into this territory. As I say, when reading paragraph 17, the fundamental thesis is that you've got to look at, to make your mind up about whether or not they have a particular advantage in relation to particular subject matter areas or topics. And I respectfully submit, for all the reasons I've given, that's the wrong approach in principle at a fundamental level. But if you are in that game, so this is really an alternative submission, if you are in that game, I respectfully submit that it may well be right that there isn't that sharper distinction. But what the judge is doing in this paragraph is to consider why it is that there isn't that sharper distinction. And if you will, the Sneddon and the Oakley cases are quite good examples of the extremities to which that can lead courts. Mr. Justice Fordham, just to jump ahead to Sneddon a little bit, Mr. Justice Fordham appeared to take that there is no real distinction between fact and assessment of risk as indicating that all, or effectively nearly all, of what the parole board thinks about and does and determines falls within territory where they have a particular advantage because they had some witnesses and therefore you need good reason. What His Honour Judge Eyre is doing in this paragraph is to go the other way. He says, well, I agree that there isn't a kind of clear baseline distinction, But the reason for that is because sometimes, even in relation to issues of fact, the Secretary of State may be just as well placed as the Parole Board, if, for example, it turns on the documents or for whatever other reason. And I say, I respectfully take my standard principle as a point prior even to paragraph 17. But if you are in that turf, then there is force, I respectfully submit, in the analysis of the long paragraph, particularly in that analysis of the difficulty. It's illustrative of the difficulty of trying to work out whether they've got a particular advantage so as to trigger the principle they thought was applicable or not. And a paradigm example might be the example of a diagnosis, the kind that was given by Mr. Justice Chamberlain. Again, how do you work out whether there's a particular advantage in relation to that or not? It all becomes very complicated and very difficult. But ultimately, the approach of His Honour Judge Keezer in this case was to come back, essentially to come back to the basic idea that the question is a relatively simple one, which is, could a rational Secretary of State reach the view that it wasn't appropriate to transfer this particular prisoner to open conditions, having regard to the reasons they gave, take into account the Parole Board recommendations and indeed its reasoning for all you will. But ultimately, if there are two views on that question, then the attack in rationality will fail. And it will correctly fail because Parliament has ascribed the primacy of decision-making in this sphere to the Secretary of State and not the Parole Board.
But isn't there a wrinkle on the facts of Oakley, which is that important to the Secretary of State's reasoning was the evidence of Mr. Fisher, which wasn't even available to the Parole Board when it made its recommendation.
My lady, yes, and I'm going to come to that on the facts, but you're right. The central concern, ultimately, and the central point in Oakley, I'll come to in a little bit more detail in a moment, but the central concern in Oakley was that the Parole Board had concluded that further work needed to be done. They themselves cited Miss Rowe's view that was thoroughly important, and perhaps unsurprisingly, important that that work should be done because of the nature of the antecedent history, the stabbing of ex-partners and the difficulties that the prisoner got into when the breakup happened, as it were. Everyone was agreed, in effect, that further work was needed. The Parole Board concluded that work couldn't be done in close, and ultimately it turned out that it could. And that was the essence of it. But how do you ascribe particular advantage in relation to that? The lady is right. You can't really ascribe particular advantage if it happens after the event. It becomes clear that that's the position. But in any event, even if one took it back, it would be difficult to work out how you ascribe particular advantage as the trigger for the analysis. And that's what we say about Oakley too. We respectfully submit that it should have started from an even more fundamentally public law type place. In other words, approaching the matter on the basis of Gilbert, and it's all a matter of rationality.
Could you just go back? I know you're going to the facts. I hadn't picked that nuance up. So the Parole Board in Oakley thought that the necessary work for Mr. Oakley should be carried out in, or couldn't be carried out in closed. Is that what you
Yes,
said?
my lady. Let me do it in a slightly different order.
I'll just be quiet.
No,
That's
no,
fine.
I'll do Oakley in principle, and now I'll do Oakley on the facts.
Yes.
It might make more sense to do it that way. But I'll take you to that. If you go to our skeleton, I hope conveniently and helpfully, we've tried to set out the factual background in Oakley in Annex 2 to our skeleton on page 28, at least it's on page 28 of mine. I should have checked at the beginning, did the court get the updated
Yes, we did.
I'm glad, thank you.
Yes, we did.
And
Thank you.
so Annex 2 is headed the factual background in Oakley.
Yes.
So we've set out there, essentially in paragraph 3, well, we set out the index offences and which basically found the concerns in paragraphs 1 and 2. So it was strong responsibility but diminished responsibility on manslaughter. I say strong responsibility for the reasons set out in the first sentence of paragraph 3 by reference to the sentencing remarks of the judge. But you'll see the seriousness of the concern And you'll see the parole board's essential reasoning summarised and quoted with underlined bits, I hope helpfully, in paragraph 3. And then again in paragraph...
No, I think the parole board starts later, doesn't it?
Paragraph 6.
So
Maybe that the first underlined bit there.
where does it say that they thought it couldn't be carried out enclosed? Is it the middle of 6? Miss McAlee suggested the package could be made available in open conditions.
Next page.
No,
Next
it's the
page.
next page. It's
Thank
the next
you.
page, sorry. It's within the quote of paragraph 7. It's right down the bottom of page 30. However, the panel has
There's no
displayed...
further work in closed conditions.
Yeah.
I see.
So you'll see from up to that point, we've got manslaughter by stabbing the ex-partner with particular responsibility for that. There was a history with ex-partners. So this was not just a one-off, as it were. There was troubling antecedent history.
Yes.
The reasoning of the panel is set out particularly in paragraph 7, as you see. You see the risk rating.
Where do I see the risk rating?
Sorry, give me a moment.
The panel assesses you cannot at present be safely managed in the community.
Yep. No, I had some different passage in mind. Hang on.
Medium risk,
Yeah,
paragraph 7.
that was the one I had in mind. And then the first two lines of the quote at the top of page 20.
Sorry, forgive me. High risk of causing serious harm to known adults.
Yeah.
That's the relevant one.
Yeah. And then you'll see the worry about obsessional behaviour in relation to relationships, particularly in handing their termination at the very top of that page, first couple of lines of the quote. And you'll see the assessment of Ms. Rowe in the penultimate full paragraph on page 30. Ms. Rowe assesses you need to do further work enclosed on the area she's identified. Unclear to the panel how this was to be delivered and so on, but further work was needed. There didn't seem to be any disagreement that further work was needed, including on the basis of Ms. Rowe's view. But the conclusion was, see the bottom of the page, the passage we looked at, you couldn't do it enclosed. And the Secretary of State's reasoning is really set out in summary in paragraph 12, in the paragraphs A to I on paragraph 12. And again, without over-summarising, because that needs to be read in full, there were understandable and real concerns about the safety of the public at this stage. There was an acknowledgement and acceptance in agreement with the Parole Board that further work was needed, including especially the stalking risk profile work identified by the lead psychiatrist. And indeed also the community offender manager. And that could be done enclosed. And there were also concerns about the honesty with which the relationship with the community offender manager was being conducted, and that was important because there was a need for a high level of support, which was less likely to be achievable in open conditions. So there were a strand of things that were worrying.
Which paragraph do we see that, please?
Paragraph 12D.
12D. No, I don't think so. I think the reference is the paragraph about honesty of the relationship. Is that paragraph? I don't think it is. It's GE.
To E, I'm so sorry.
That's all right.
My notes
Paragraph 12E.
My notes came out wrong. Yeah.
And why is that important, do you say?
Because if there is concern about the honesty of that engagement, it's going to become that much more difficult in open conditions for the progress to be made. It's another reason for being cautious. If you need that, if you've got complex needs and you need that support, not being honest, that's another reason for concern. But I essentially make two submissions about this before one gets to the judgment of the court on the judicial review. The first submission is that there's nothing remotely irrational about that reasoning or those conclusions. The Secretary of State doesn't have to prove that the Parole Board was wrong. There are obviously very serious concerns in relation to this individual. In open conditions, they will be exposed to people in the community. You need to be pretty sure if you've had someone who's got a long history of the kind that this individual had, where the index offence was one of stabbing an ex-partner to death. There's nothing remotely irrational about taking the view that was taken by the Secretary of State, which was obviously conditioned to a significant extent and relied to a significant extent on strands of the conclusions that the Parole Board had reached. But even if it's necessary to enter into the sort of fine chopping in the later case law to try and allocate different subject matter topics into more or less respectful brackets, if I can put it that way, the Secretary of State was perfectly entitled to disagree for the reasons that were given. And to come directly to the judge's judgment below, His Honour Judge Keyser set out the reasoning in question and the reasoning for concluding that that was the position, particularly perhaps at paragraph 16 of Annex 2, if you're still there. So Annex 2 to the skeleton, sorry.
All right.
He's given you a quote there in paragraph 38.
Paragraph 38 of the judgment.
Yeah.
Yes. So I'm looking at the judgment at the moment.
Paragraph 38, and in particular, the final bit of it. Where he's on that. Is it a past event? Is it fact? Is it something else? I say that's, we respectfully submit that even that exercise doesn't need to be undertaken. But even if you do, he's right. It's got anything to do with credibility, their assessments by the Parole Board in brackets of the claimant's needs to undergo further work and the availability of resources. An assessment of the claimant's need to undergo further work is fundamentally a matter concerning risk. Question of the resources of the closed estate to address a particular need is not, in my view, one in respect of which the Parole Board enjoys any particular advantage over the Secretary of State. And then goes on to consider the points that are in 40 and 41. And indeed notes in 43, you might choose to note, that the judge noted that the Parole Board appears to have subsequently come to some conclusions as Secretary of State about the need to assess Mr. Oakley's stalking behaviour.
That's really forensic, isn't it?
Probably, but as I say, the two submissions I make don't need to go down there. The question is a simple one of rationality per Gilbert. Even if you do, judge correct about which side of the respect line the particular bits and pieces fell in that case.
I can maybe thought in this decision, the judge was, as it were, expressing his view at the outset, but then attempting to tiptoe through what might be described as the minefield of other decisions. In other words, the principles that had been identified wrongly, you would
In
say,
the first instance,
in the first instance decisions, because
It was a fair
he was trying to address those in the course of his judgment.
yeah, that's why I make it as a primary and an alternative submission.
Yes.
Sneddon, the judgment of Mr. Justice Fordham in Sneddon is in the call bundle at tab 13. And again, you have the relevant bits of it, I hope helpfully collected, but refer to whichever one you want. But the factual background of Sneddon is Annex 1 to our skeleton, and it follows essentially a similar format. Whereas what was the Parole Board's advice with relevant quotes? What were the Secretary of State's reasons for reaching a different view, concluding it wasn't a wholly persuasive case for transferring at that time, and what did the judge then make of that when the judicial review arrived? And I kind of touched on the submissions I make in relation to this judgment. It is perhaps the paradigm example of where you get led to if you start trying to ascribe relative expertise as part of the integral exercise that's said to govern rationality. And if you do go down that route and you recognise that there isn't an absolutely clear distinction between fact and assessment, where does that lead you? Well, the answer on Mr. Justice Fordham's reasoning is that it appears to lead you to a position where almost anything that the Parole Board concludes requires the Secretary of State to produce good reason for disagreeing with, in effect acting as in a kind of quasi-appellate capacity, or with the Parole Board as being presumptively binding. So it's any, as he put it in 28(6) of his judgment, that's Mr. Justice Fordham's judgment,
Yes.
you'll see the A, B, C. Those are the ones where you need very good reason. But it's any question of fact from evidence at the hearing.
Where does it say that? Oh, yes, I see.
Yeah.
Yep.
Or expert evaluation of risks, such as professional diagnosis or professional prediction. C. I mean, if you take A, B and C together, particularly B and C, you've pretty much got the entire territory that the Parole Board is almost bound to get into on any request for advice. My respectful submission is that cannot be right, because the effect of it, it's perhaps as well to make these submissions, the effect of that, if it is right, which just shows you how it goes too far, the effect, if that is right, is to untether the test from its principled rationality base.
Well, he does talk about rationality at 29,
He does,
but he says that all of that engages the principles listed above.
exactly so. But what you do if you take that approach and you require good reason, you require that sort of challenging process to the Parole Board as a judgment, in effect, by the Secretary of State, you untether it from rationality. And rationality, we know from Gilbert and the earlier authorities, is essentially if there are room for two sensible-looking views, then it's for the statutory decision-making. This is a challenge to substantive rationality. And we know that rationality is the test because the Court of Appeal have told us that in Gilbert. But more importantly, or as importantly, it shrinks the space within which the Secretary of State can simply rationally disagree, so that almost every conclusion of the Parole Board after a hearing would need to be subject to this thoroughly good reasons and were they wrong and all of that exercise, which is inimical to the statutory intention, I respectfully submit. It comes close to, if not beyond, the point where the Secretary of State in effect has to show that something went wrong with the Parole Board reasoning or decision making. It comes very close to that in 28(5) of the judgment. And there is in this judgment no acknowledgement whatever of the factor that the Court of Appeal considered so important in Gilbert at paragraph 70, namely the expertise residing in the Secretary of State in the management of the prisoner state and indeed in the assessment of the risks posed by prisoners. So we respectfully submit that Mr. Justice Fordham's judgment is not merely wrong in its appreciation of the correct approach in principle, but it is an example of the difficulties of going down the route that the subsequent High Court case law has gone down, and the untethering of that from the principled orthodoxy set out in Gilbert. So far as Sneddon on the facts is concerned, again, I emphasise there's no need to consider these perhaps other than as examples of fact patterns and the application of what we respectfully submit as a wrong approach, and that is because, as we set out in Annex 1, paragraph 13, the Secretary of State has in fact reconsidered and accepted the recommendation following Justice Fordham's judgment. I've dealt already with wrong approach, But what the judge does when he gets to the reasoning on the facts is in effect to require the Secretary of State to address at a thoroughly granular level of detail all of the points made by the Parole Board in relation to risk. And in relation to Mr. Sneddon, as you see from Annex 1 on the summary, I'm not going to go through the detail of it, but as you see from that, Mr. Sneddon had been convicted of a range of serious sexual offences, including rape.
It was child rape. All of the offences were child rape. Is that
Exactly
right?
so. So about as serious a risk flowing from the antecedents as one could possibly imagine. But also, there was evidence before the Parole Board that there had been, on previous occasions when he'd been put into open, what was described as serious risk-taking, putting him in positions where exposing himself in the, not in the literal sense, but exposing himself to risk in the community when he was in open on previous occasions in the past. And as it was put by the Parole Board, I think poor consequential thinking when he'd been in open in the past. And that, as the Secretary of State concluded, particularly having regard to the antecedents, was a matter of the most serious concern, particularly given the past offending. So too, it might be thought, was the conclusion of the Parole Board, with which the Secretary of State didn't have to disagree. The Secretary of State positively agreed with this. That there had been, as the Parole Board put it, in the giving of evidence by the prisoner to the Parole Board, considerable, quote, impression management. Might be thought to be an alternative way of saying presenting himself and his risk in a less than entirely honest light. But if you put those two bits and pieces together, you end up with real concern and real legitimate concern. Now, what the judge
I haven't
did...
come across that phrase before, impression management. Is it a technical phrase?
I don't know, I'm afraid.
Yeah,
It is.
yeah. It's commonly used.
It's commonly used.
Yes.
I hope I've...
Creating a false impression.
Yeah, creating a false impression. But creating a false impression bearing on the risk the prisoner posed.
Thank you.
What Mr. Justice Fordham then ultimately does on the facts is to say that what the Secretary of State did in the decision letter was in effect to ignore the Parole Board's additional conclusion was that there was, quote, little evidence to suggest that the past risk-taking remained a current concern. That was one of the judge's worries. And the second one was that there had been some shorter periods when the prisoner had been in open on previous occasions where he had not, or there was no evidence that he'd taken risky behaviour or serious risk-taking. And true it is that both of those things were found by the Parole Board and were not specifically addressed by the Secretary of State. But, and it's a pretty big but, the question of risk-taking had not at least been fully tested because for most of the relevant period, the prisoner had in fact been in closed conditions. Moreover, the finding of the Parole Board was only that there was little evidence to suggest that remains of current concern. But that does not suggest that there was no current concern. And it may well be that there are any number of reasons why there wasn't positive evidence of risk-taking. What we do know for absolutely certain on the Parole Board's findings is that on previous occasions, and a number of them, he had undertaken serious risk-taking behaviour when in open conditions. And most importantly, or as importantly, had conducted, even in the Parole Board hearing, impression management. So the combination of those two might be seen in the light particularly of the past index offences to be a matter of the most considerable concern in relation to public protection and indeed whether it was ready to move to open. But the ultimate question, I come back to it, is whether a rational Secretary of State, for the reasons that are given in the decision letter, could conclude that the prisoner should not be transferred to Oakley. And I respectfully submit that there's only one answer to that question in relation to this individual. So those are my submissions in Oakley.
Been very helpful, Sir James. Thank you.
We've you'll have seen that we've done it on the basis I would try and do everything.
Yes, well, that's
and without
obviously a
affecting the
sensible way of proceeding. Let me just, any questions?
You want to ask him what he's supposed to do about Sneddon. He has been released, but so we're just going to declare the principles.
Yes. Yes, I think this almost unravels itself, but whatever our decision on either case, or perhaps Mr. Sneddon because he's been released, the later decision has overtaken events. So we just reach our conclusion, ignoring it, so to speak, setting out any principles and findings in relation to the judgment below.
My lady, yes, I think that is right. And the only reason for taking any time on the facts of Sneddon are because they're not a bad example of how those
No, I
principles
understand.
should apply.
No, I understand. It won't affect the decision that was taken subsequently in the light of Mr. Justice Fordham's, and nothing that we say will affect that.
No.
Good. Thank you. Sir James, we're also conscious that you both were kind enough to put forward a running order with some time estimates. We should make it clear you must take as much time as you need. If we can do it in a day, then so much the better, but if we can't, that is not a problem. Thank you, Sir
My lady,
James.
I anticipate we will comfortably finish today.
Good.
Like Sir James, I expect I'll be much quicker than the time estimate that we
Good.
offer to your ladyship.
Always better to err on the side of caution at the outset.
I'm grateful. The reason for that is because realistically the issue in my respectful submission between the parties is a relatively narrow one, because my learned friend's primary position is nuanced by his alternative position, and his alternative position is pretty close to where we end up. And we respectfully agree that the key issue in these appeals is what does a reasonableness or rationality review require when the Secretary of State seeks to depart from findings made by the Parole Board. And the test that we offer to the court is as follows. We say that the Secretary of State must accord weight to the Parole Board's recommendations, although the weight to be given will depend on the matters in issue, the type of hearing before the panel, its
Sorry,
finding,
the
the type of hearing before the panel,
Yes.
its findings, and the nature of the risk assessment it had to make. And then secondly, we say that on matters in respect of which the Parole Board enjoys a particular advantage over the Secretary of State, the Secretary of State must give clear, cogent and convincing reasons for departing from those findings. And that second aspect of the test reflects my learned friend's alternative position, because as he realistically accepts, Hindawi, and in particular how it's proved in Gilbert, recognise that where the Parole Board has made findings of fact, the Secretary of State requires a very good reason to depart from those findings of fact. My learned friend says as much in his replacement skeleton at paragraph 11. And the difference between the parties is that we go one stage further, and we say that very good reason can, but not always will, be required in other categories of case also. So we say that very good reason can be required in categories such as a risk assessment or an expert assessment. And so our position that we adopt reflects the judgment of Mr. Justice Fordham in Sneddon, but also the well-established position before Sneddon, in particular, the judgments of Mr. Justice Chamberlain in Oakley No. 1 and Mrs. Justice Stein in Wynne. And insofar as His Honour Judge Kaiser King's counsel in Oakley No. 2 suggested that a lesser standard of review will always apply where the issue is an evaluation of risk, we respectfully observe that he fell into error. And so to make those points
Sorry,
good.
Mr Bunting, you mentioned Mr Justice Chamberlain in Oakley 1,
Yes.
and then you mentioned another one I missed.
Mrs. Justice Steen in Wynne.
Thank you.
There are others also which I'll bring the court's attention to, but those two in particular. And insofar as he adopted the opposite approach, His Honour Judge Kaiser, King's Counsel in Oakley number 2, fell into error. But to make those points good, I'm going to structure my submissions in the following way. First of all, I'm going to stand back from the authorities and I'm going to seek to explain why the Parole Board can enjoy a significant advantage over the Secretary of State. And that involves looking at 3 factors in particular: the Parole Board's judicial nature, its specialist members, and the relative information that it has. Then, in the second part of my submissions, I will explain why risk assessment and expert assessment can require very good reason for the departure. So turning to those first 3 points about the structure of decision-making in these cases, we agree and accept that the power to transfer a prisoner is a power entrusted to the Secretary of State. We agree also that there is no requirement to refer such cases to the Parole Board in the statute. And we agree that the power to refer cases to the Parole Board is a power to refer cases for advice. However, all of the cases in the bundle and the cases before this court are cases in which the Secretary of State has chosen to refer. And the reason he does refer in almost every case is because, firstly, these issues are of extreme importance to the prisoner, because without a transfer to open conditions, a long-term prisoner is going to be unlikely to persuade the Parole Board that they can be released. And because, as a result, there is a high standard of procedural fairness that applies. And that's where we see the judgment of Mr Justice Keith in Youssef at supplementary bundle page 100, paragraphs 26 to 27. And so because these are very important issues, and because a high standard of fairness applies, the Secretary of State commonly refers this point to the Parole Board for consideration. And that is where the comparative advantage begins. It begins because, in so doing, the Secretary of State obtained judicial determination on the issue of risk, which is central to the question of transfer. And so the first point, which is a point that my lady raised in oral argument, is that it is recognised that in answering that question, namely whether a prisoner should be transferred to open conditions, the Parole Board is a judicial body. And of course, the Parole Board is well recognised as a court when it's deciding the issue of risk for the purposes of release. And commonly, the Parole Board will do both questions at the same time. So it will say, I decide that this prisoner should be released, or this prisoner ought not to be released, but nevertheless, I recommend a transfer to open conditions. The first of those decisions is binding, see statute. The second of those decisions is advisory, see statute. But nevertheless, the Parole Board adopts the same forensic and judicial approach when answering both questions. And 2 authorities in particular put that proposition beyond doubt. The first is the decision of this court in Gourlay's case, which is in the supplementary bundle at page 174. The issue in Gourlay was whether or not the costs protection that applies to courts can apply to the Parole Board when a decision in respect of open conditions is being challenged. And Lord Justice Hickenbottom decided that it did because the Parole Board is acting judicially. So at 174, in particular at Roman numeral 5, whether dealing with decisions concerning release or decisions concerning transfer, the board performs a similar function and it has to obtain relevant material from NOMS, that's the National Offender Management Service, and the offender himself, and evaluate that material in making an assessment of the risk posed by the offender and whether that risk is at an appropriate level for him to progress by way of transfer or release on licence, as the case may be. In respect of release, it has to reach its own objective judicial decision to comply with Article 5.4. In respect of transfer, it reaches its decision in the same way and to the same procedural standards. It has to use the same procedures for practical reasons. And then that approach, of course, is also reflected in the Supreme Court's determination in the case of Pierce, which is in the same bundle at page 301. At paragraph 6. And the judgment of Lord Hodge and Lord Hughes in that case says, in some, but by no means all circumstances, the board also has a separate function in respect to the question whether the prisoner merits transfer to a less severe regime, especially but not only to open conditions. In this case, the board's role is to advise the Secretary of State who makes the decision. In this role also, the board fulfills a judicial function, and the principles on which it acts are in many respects similar to those applicable to directions on release. And so it is accepted at this court and in the Supreme Court that the parole board is acting judicially. And that proposition, my lady, doesn't just have a symbolic importance. It reflects the way in which the parole board approaches its task. The parole board's judicial nature, in our respectful submission, qualitatively improves the standard of decision making that it takes. We see that, of course, reflected in Hindawi in the core bundle at page 185. Where...
Sorry, page 185.
Sorry, I think it's actually paragraph 50 of Hindawi that I'm looking for, which is at page 196.
Sorry, so this is tab 11. No, I've got lost. My fault. Where are we?
It's tab 10 of
Thank
the core
you.
bundle.
Tab 10, core bundle.
Page 196 of the electronic bundle,
Thank you.
and it's paragraph 50.
Yes.
The parole board is expert in the assessment of risk, immunised from external pressures. The assessment of risk by the application of publicly promulgated criteria is a task with no political content. The panels that carry out the work operate in a manner much like a court, sifting and analysing the evidence, and when there is an oral hearing, making relevant findings on disputed issues which could not be resolved by way of the papers. The task is not one to which the Secretary of State can bring any superior expertise. See the judgment of Lord Bingham in Clift. And that passage in Clift was also, of course, approved in Banfield. And so what we have here is the recognition as long ago as Hindawi of the parole board taking these decisions in a careful, forensic and non-political way. And that then gives us...
Forgive me, Hindawi was a release case or
Yes.
a transfer case? It was a release case.
Yes,
So the last sentence of
paragraph 50.
paragraph 50 doesn't help you.
No, it does. It was relevant in that case, but the same principles apply here for the reasons that we've just seen in Gourlay and Pierce, that you have a judicial decision-making procedure. And that's why we see that judicial determination being reflected in the parole board rules. And so to give the court the references, both the prisoner and the Secretary of State are classed as parties in the parole board rules. That's Rule 1, core bundle, page 15. Being a party gives the prisoner and the Secretary of State the right to be legally represented. See Rule 10, core bundle 21. It also gives them the ability to call witnesses. That's Rule 13, core bundle, page 22. The Secretary of State must provide the Parole Board with all relevant papers.
Before you go on, can I just return to this question you raised about the position of the Secretary of State
Yes.
as a party, because that was explicitly dealt with in Hindawi, where I think the point on fairness that was raised in relation to that was in the event abandoned, it being suggested initially that the Secretary of State couldn't take a fair decision if he was a party, because it recognised that as a matter of practice, that's not what actually happens.
Yes.
That's right, isn't it?
I think then what ultimately happened in Hindawi is that the same people who had been the instructing representatives
But that's
in
a different
Hindawi's
point.
case.
That's a different
Yes.
point.
So the point, all that I'm saying is that the Secretary of State is a party in the parole proceedings, and therefore you have this, the Secretary of State gives him procedural rights in proceeding before the court. I don't seek to develop the principle more widely than that. And so just to finish off where I was at, the relevant papers is Rule 16 on page 25 of the core bundle. The ability to make written representations is Rule 18 at page 28 of the core bundle. And the ability to examine witnesses and make oral submissions is at Rule 23 on page 32. And so the starting point, the first point which I make, is that the Parole Board is acting judicially and has a strict procedural standard that requires both the Secretary of State and the prisoner to set out their case on risk and then to enable that question to be determined. The second point is that the Parole Board is not only a judicial body, but it's a judicial body with specialist members. And so as the court will have seen in the perusal of the authorities bundle, where there's an issue in particular of disputed expert evidence, the Parole Board will commonly include on its panel a specialist in that area of expertise, whether that be psychology or psychiatry. And then the third point is how well informed the Parole Board is when it's approaching this task, because the panel will frequently receive bundles of many hundreds, if not thousands of pages, including the full history of a prisoner's progress through the custodial estate, and it will then be able to test that evidence through written submissions and crucially through oral questioning and argument. And so, for example, if there was a concern about impression management at one stage in a prisoner's progress through the custodial estate, that concern can be tested directly with the prisoner. It can also be tested directly with the relevant witnesses. And so the court will see that structure of decision-making in both of the cases before the court. So in Sneddon, first of all, at page 526 of the core bundle.
Sorry, 526.
Yes, I'm sorry. I haven't been working on tabs, but it's tab 22, my lady.
Thank you.
And it's just simply the reported version of Sneddon's Gate.
Yes.
And so my lady will see at the top of the page, just between A and B, the Parole Board panel was comprised of 2 independent members and a psychologist member.
Sorry, it's my fault. This is not in the judgment of Sneddon.
Yes, it is. My
It
lady.
is. Paragraph
It's paragraph 4.
4. Thank you. Yes.
So the Parole Board panel was comprised of 2 independent members and a psychologist member. An oral hearing commenced and was adjourned, resumed on the 3rd of February. There was a 604-page dossier of relevant documents. There were reports and updating reports by the prison offender manager. That's the probation officer in the prison. The community offender manager, that's the probation officer in the community. And the prison psychologist. All 3 of those professionals also gave oral evidence. The claimant gave oral evidence and was questioned by panel members who also questioned the professionals, including as to the implications of the claimant's oral evidence. By a 14-page determination dated the 15th of February, the Parole Board set out its reasoned recommendation that the claimant be transferred to open conditions. So there you see the practical reality of the points that I made. A forensic focus carried out by an expert and judicial panel on the very issues that the Secretary of State is concerned about. And my lady will see the same thing in Oakley, and if I can do this by reference to Oakley number 1, because it's effectively the same point, and this is in the core bundle at page 481 or tab 19.
This is the authorities bundle.
Yes.
Yep. Tab.
Tab 19, page 481. And it's paragraph 7, my lady.
Yes.
So the court will see that a panel was convened consisting of a judicial member, 2 psychiatrist members, and an independent member. And pausing there, in my experience, it's relatively rare for the Parole Board to sit as a panel of 4, but it did so in this case, including 2 specialist psychiatrist members. The panel heard oral evidence from Mr. Oakley, Dr. Kevin O'Shea, a consultant psychiatrist who was instructed by the prison service, Mr. Kevin Meek, a wellbeing team manager, Ms. Emma Marcia and Kirsty Phillips, prison offender managers, and Ms. Anne Rowe, the community offender managers. It considered written and oral representations on behalf of Mr. Oakley and on behalf of the Secretary of State against. So it had oral and written representations from the Secretary of State. It also saw a dossier containing 669 pages, which included victim personal statements from the mother and father of the victim. Then we can see at paragraph 8 that the panel's determination in that case was again forensic, 16 pages, including an analysis of the index offence, the previous offending, an analysis of the risk factors, a long and detailed summary of the evidence of change, a current assessment of risk, evaluation of the effectiveness of plans to manage that risk, and a final section including the conclusion and decisions. And so both of these cases demonstrate the practical point which I'm seeking to develop, that procedurally, substantively, forensically, the Parole Board is acting judicially and brings its expertise to the same risk question that the Secretary of State is going to determine. And so those 3 points, the judicial nature, the expert nature, and the quality of evidence before the panel, can be contrasted with the Secretary of State. The Secretary of State obviously doesn't act as a court, but rather acts administratively. The decision makers are, broadly speaking, civil servants, and I don't mean that in a deprecatory way, but they aren't judges or specialists in psychology or psychiatry. There isn't any evidence that they receive specific training in risk assessment or in the sifting of evidence or in the crafting of a decision letter. They don't hear the evidence for themselves. They do not generally consider representations even from the prisoner. These are they consider essentially internal views, and then they lead to a decision which is considerably shorter, less technical, and less forensically focused than the kinds of decision letters that we have seen in both Oakley and Sneddon. The Secretary of State doesn't even have a transcript, commonly, of the oral evidence before the Parole Board in taking any of its decisions. So there is no suggestion in either Sneddon or in Oakley that the Secretary of State asked for a transcript or even for a summary or a gist of the evidence that wasn't contained in the decision letters themselves. And we can see this in a case in the supplementary bundle, in which I think the soon-to-be sworn-in Dexter Diaz, King's Counsel,
This afternoon.
gives judgment. It's a case called Zen Shen. And it's tab 18 of the supplementary bundle, my lady. Relevant electronic page reference is page 377.
Yes.
Sorry, which tab was it?
Tab 18 of the supplementary bundle, electronic page 377. And so at paragraph 57, the learned deputy judge, as he then was, says, what is this of significance? Is it no witness attending the panel hearing expressed a view contrary to the need for the testing to now be open and endorsed at the time was now right? Having heard all the evidence, including the updating evidence, the panel had a significant advantage over the defendant on this topic. Then at the bottom of that paragraph, this is not a cautionary note about the limited extent of his improved insight. That was obvious from the evidence given at the panel hearing, evidence that the defendant did not have and thus misconstrued. And the relevant passage for our purposes is what follows, because we see witness statement from Gordon Davison, a very senior civil servant in the Ministry of Justice who appears as the decision maker in many of these cases. Mr. Davison states in his second statement that it is not the defendant's practice to re-evaluate all of the oral evidence heard by the parole board, and this would not be appropriate. And the deputy judge says, I can readily envisage that in certain cases the lack of hearing evidence will be of no practical consequence. But obviously where, in this case and in many cases it will be, because it results in the Secretary of State taking into account matters that were wrong or failing to take into account matters that were important. His lack of forensic accuracy stemmed from the fact that he did not have the hearing evidence. And so the Secretary of State isn't as well informed as the parole board in these cases. The decision maker doesn't even consider the parole dossier, but rather a summary of the evidence in the parole dossier. And as such, the process that the Secretary of State follows is neither judicial nor forensic. And I regret to observe that sometimes the approach to recommendations of the parole board from the Secretary of State can also reflect a point which was an issue in Hindawi, because in Hindawi, the divisional court explains that risk assessment isn't a political question, but because the approach to acceptance of recommendations by the parole board can change so fundamentally depending on who the Secretary of State is, the inference that we draw from that is that sometimes political questions can creep in. We see this firstly from Zen Shen itself, as if the court turns to page 386 within the same authority. We can see that there has been a change. So at paragraph 89, Mr. Justice Diaz notes the hearing bundle includes a report from the Prison Reform Trust. It is entitled The Long View, The Changing Face of Parole. In the introduction, the Trust Director writes that as a result of the defendant's policy changes in the summer of 2022, made without parliamentary scrutiny, almost all opportunity for indeterminate sentence prisoners to move has disappeared. Overnight, a 94% acceptance rate has turned into an 87% rejection rate. And the chief executive of the parole board observed that the published evidence is strong. When a prisoner is afforded a successful period in open conditions, it makes the public safer and increases the chance that the individual can succeed on release. And he adds, it's hard not to be concerned that since June 2022, the Secretary of State has chosen not even to ask the board's advice in a much higher proportion of cases, and his officials have chosen not to take our advice in nearly 9 out of 10 cases where we have recommended a progressive move to open conditions.
Mr. Bunting, can I ask what we draw from that? What conclusion are you asking us to draw from that
Well,
material?
Realistically, the proposition that I'm taking is that the parole board has a significant advantage because it acts judicially and it's immune
No,
from...
I understand that point, but in relation to what you're saying here.
I'm comparing and contrasting that to the approach that the Secretary of State can take.
I think you're going a bit further, or you were trying to, weren't you?
Oh, well, I was about to.
My lady is, I think
what I was about to
tease
respect.
out.
I think what I was about to respectfully observe is moving away from some of the political language that's used in those witness statements, my lady. The point that we can see is that there is a massive change depending on who the Secretary of State is. Because what the evidence then follows in another case called Allen is that when the Secretary of State was replaced by Alex Chalk, then this approach, the reduction in, there was a significant reduction in the number of rejections.
Well, I think that is quite dangerous territory.
And so I put it,
Help us very much.
I put it no more highly than
reflects,
that.
I mean, it's the point that Sir James has made repeatedly, which is Parliament's decided to give the power to the Secretary of State, and by definition, administrations come and go.
Yes, I put it no
And
more
so do
highly.
Secretaries of State.
Yes, it is for the Secretary of State to decide. But
And in addition to that, if Parliament has decided, or the decision has been made, that the Secretary of State does not need to ask, does not need to involve the Parole Board.
Parliament hasn't required the Secretary of State to do that in statute. Where the reason the Secretary of State does, as I've said, comes from other sources
We have to
of law.
accept that situation as it is.
Yes, I accept that situation, and perhaps this shape
Your
through
headline
evidence
point, I
hasn't
think,
helped.
we well understand.
The starting,
The judicial body point
Yes.
and the specialist members, well informed, and therefore you say much better placed than the Secretary of State.
can be much better placed than
Yes.
the State.
Well, just reading ahead in Zenshen, the Secretary of State, by his or her officials, whichever it was at the time, was able to reach a decision in 2 hours, 17 minutes,
Yes,
when the casual reader would have taken more than that just to read the material, never mind to think about it.
yes,
So perhaps not surprising that the shortly to be Mr. Justice Dias applied the rationality test and came to the clear conclusion that the decision was irrational.
yes. Or another way of looking at it, my lord, is that Mr. Justice Dias accepted that there are circumstances in which the Parole Board has a significant advantage. And this was one because the Parole Board had significantly more time to consider the material. But where all of this brings us, my lady, is that the difference in the quality of forensic inquiry gives the Parole Board what Mr. Justice Fordham describes as a due process advantage. Now, quite how one labels that, I don't mind. But our proposition, the starting proposition, is that the Parole Board can have a significant forensic advantage over the Secretary of State in these cases. That's not to downplay the expertise of the Secretary of State himself. And that's exactly what Mr. Justice Fordham explained in the most recent case in the core bundle, Carrigan. So that's tab 23. And it's paragraph 57 of that at page 564.
Sorry, tab 23, 564.
Yes.
Yes.
So what Mr. Justice, he's explaining perhaps himself in view of what he describes as his earlier case going to a higher judicial altitude. And he says at paragraph 57, it is right, of course, risk specialism with the advantage of the expertise of his department, that the Secretary of State is and remains the primary decision maker, and that the focus is on whether the Secretary of State's decision was reasonable. But the board has specialist decision makers with the institutional advantages of independence and the rigours of due process. Yes, the Secretary of State has relevant risk experts, but the Secretary of State puts relevant risk experts forward to give expert risk-related evidence to the board in a process where that evidence emanating from the expertise of the department can be considered and tested. This is a significant combination of circumstances involving institutional and due process advantages. When the board is advised before the Secretary of State makes the final decision, I do not, for my part, think that very good reason for questions of significant advantage and good reason for other questions impose unrealistic or inapt standards. And so that's the first of the points which I make, my lady, that the Parole Board can have a significant advantage, and therefore the starting point in the test is that there is a weight to be attached to the Parole Board's recommendation. That weight can shift depending on the factors which I've identified.
Depending on
The factors which I've identified.
Yes.
And so to use Sir James's approach, where there is a factual finding or a finding in the old-fashioned language of the make of the man, then that's a matter in which the parole board has a particular advantage and very good reasons are needed to depart. And all we say that Mr. Justice Fordham did in Sneddon's case is to recognise the reality that it's not just in credibility assessments that the parole board can have that advantage. And this is the second part of my submission. The parole board can also have that advantage in questions of expert evaluation of risk. Mr. Justice Fordham didn't say that the parole board always has that advantage in those types of questions. And that's really why we respectfully observe that Lady Justice McCurran granting permission suggested that she didn't recognise some of the criticisms that were being made of Mr. Justice Fordham's judgment. And the passage in particular is Core Bundle, page 537, at paragraph 28, subparagraph 6.
This is, sorry, in the judgment of Mr. Justice Fordham, is this?
Yes, my lady. I'm sorry, I've done this by reference to the reported.
So the key paragraph 28.
Yes.
Yes, subparagraph 6.
Yes. So when one looks at that, this is questions of significant advantage. And it says, on such questions, the reason the basis for rejection will require very good reasons, clear, cogent and convincing reasons. In respect of evaluative questions, on questions where the panel has a significant advantage. And then he gives examples of where the panel can have significant advantage. Paragraph A, credibility after oral evidence at a hearing. My learned friend Sir James accepts. Paragraph B, any question of fact from evidence at a hearing. And paragraph C is questions of expert evaluation of risk, such as professional diagnosis or professional prediction. And our submission is that Mr. Justice Fordham is not there saying that in those categories there will always be a substantial advantage. And I make that submission for two reasons. Firstly, because the authority which he cites for this proposition is Oakley number 1. And Oakley number 1 doesn't say that. And secondly, because the last sentence of paragraph 28.6 says that there is no bright line distinction excluding questions of evaluative assessment about the nature and level of the risk and its manageability from falling within this category. And that sentence would mean nothing if Mr. Justice Fordham intended this passage to mean that in that category there will always be a substantial disadvantage. All he's saying is that there can be a substantial advantage in those cases. And we respectfully agree with him on that.
Well, why is it necessary to go further than what is said in Gilbert by Lord Justice Sales in paragraph 92, I think it is,
Well,
where he talks about it in a, as I said before, in contingent terms? Why does the court need to go further than that,
well, I think what
setting out what the approach that should be taken?
the answer which I would give, my lady, is that that paragraph has to be properly understood, because there are two ways of reading that paragraph. One, which my learned friend Sir James advocates, which is that that paragraph is setting out no more than a rationality standard in every case. Another way of reading that paragraph is that it itself recognises that the parole board can have a significant advantage on certain questions and approves the policy that was then in place, which required the Secretary of State to find an error in the parole board before rejecting its recommendation. And so when I come to Gilbert, which I will in a moment or two, I want to make those points because Gilbert, properly understood, recognises that the parole board has a significant advantage on certain cases or in certain categories of case.
But even if that is right, why does that require the sort of very good? What if I have a good reason on a question of significant advantage, but not a very good reason? What is one to do with this sort of analysis in practice?
Well, we respectfully suggest that what matters is what the language used by Lord Justice Sales, as he then was a sufficient reason.
Yep.
And so that adjective, sufficient,
Yep.
reflects that there can be a sliding scale.
But if we're looking at Miss Justice Fordham's judgment, what if I have a good reason, but not a very good reason, on what he identifies as a question of significant advantage? If I only have a good reason, will my decision be unlawful if I choose to reject?
Yes,
Right.
because you haven't shown a sufficient reason, to use the language of Lord Justice Sales, in Gilbert.
And you say that that is what the public law test of rationality carries with it?
In this context, given where we started, namely the substantial due process advantage that the Parole Board enjoys. And also the point which I'm going to develop now by reference to Sneddon, the fact that evaluative questions such as the level of risk and expert analysis can also require findings of fact. And so you can't make a bright line distinction between findings of fact, very good reasons, evaluative questions, no good reasons, because you can't always disentangle one from the other. And Sneddon's case on the facts recognises that, because as we see at page 540, paragraph 38, that the very issues that my learned friend James was concerned about were probed with the prison psychologist. And that led to the conclusion of the Parole Board that there was little evidence that past risk-taking behaviour remains a current concern. And then also, at paragraph 45 on page 542 of the core bundle, the professional witnesses whose evidence was probed and tested by the panel, including in light of the claimant's oral evidence, were unanimous as to the manageability and achievability of the type of monitoring that was needed, about the confidence as to warning signs being picked up. This evidence and its unanimity were key to why the risk to the public was assessed by the panel as considerably outweighed by the benefits of a period in open conditions. The professionals were well placed to make their assessment of those questions of risk and its manageability. The panel was in an advantageous position in probing the views of the professionals at the hearing. The panel's assessment, adopted having fully tested the professionals' unanimous assessment, was cogent and coherent. And so, in other words, what Mr. Justice Fordham is recognising is that on the evaluative question of whether risk is outbalanced by public concern, the Parole Board had expressed a view on that, drawing in all of the due process advantages which I have set out. And so you couldn't just simply say this wasn't a finding on the credibility of the claimant and therefore very good reasons weren't required. This was a point on which there was a significant advantage. And that's why we respectfully suggest that Lady Justice McCurr was again, with respect, correct to refuse permission to appeal on the facts in Sneddon's case, because as she said, the reasons given by Mr. Justice Fordham on the facts were compelling. And my lady, the reference to the permission decision is at core bundle page 61. And so that's what Sneddon decides. It decides that in certain kinds of case...
Sorry, can I just understand your submission on that? Core bundle 61.
Yes.
What are you saying? That Lady Justice McCurr simply granted permission on the principles?
Yes.
But you accept that if Mr. Justice Fordham, if he got the principles wrong, then the correct principles have to be applied by us to the facts?
No, because
you saying?
that would be outside the grant of permission in the case.
Well, I don't understand that. Let's have a look. Core bundle.
It's tab 10 of the core
Tab
bundle.
10. I haven't got a tab page.
61.
I've
Oh,
got,
sorry,
I've got
maybe-
ABC.
Sorry, B111.
B.
B111. I'm sorry, my lady, there are different page references at the bottom of the page.
So, what was ground 2? Perhaps you just take me to the appellant's notice.
tab 5.
Sorry?
Tab 5, page B64.
B64.
So ground 2 was the application to the facts.
But that is all contingent on ground 1. Ground 2, as it stands, assuming that Mr Justice Fordham was right, then no self-standing permission on that. But I may be wrong about this, but I will need help if it's going to be suggested that the granting or refusal of permission on ground 2 as it stood prevents us from interfering with the result on the Sneddon case if the wrong approach in principle was applied. I mean, it's nonsense to say that if we find that the wrong approach in principle was applied, nevertheless, we can't do anything about the outcome.
The difference, in my respectful submission, between ground 1 and ground 2 is that ground 1 says that Mr Justice got the approach wrong.
Yes?
And that the approach was in fact simple rationality.
Yes?
And ground 2 says applying the simple rationality test,
No.
it was wrong in the facts.
No, I think ground 2 is saying, well, let's see. It's not clear to me.
It says Mr Justice Fordham was not entitled to conclude the Secretary of State's reasons for refusing the transfer were anything other than rational and or amounted to good reasons for disagreeing with the Parole Board's advice. And so ground 2 is applying the Secretary of State's test.
Well, that's not the way it's been argued. And I think, have you not addressed the merits, and you are addressing the merits of Sneddon?
No, well, I'm simply saying that Sneddon demonstrates as an example that questions relating to the evaluation of risk can be tangled up with questions relating to credibility. And therefore, there can be, in this category of case, a significant advantage for the Parole Board. That's all I'm saying.
Okay. Just so you know, at the moment I am struggling with the notion, having granted permission on ground 1, if ground 1 is good, and obviously that is what we are hearing submissions on, that we are not entitled to apply what we would then, if you failed, be applying the correct approach to the facts in Sneddon. But that is actually what you're saying Lady Justice McCurr had in mind when she granted permission on ground 1.
Well, that's how I have understood ground
Right.
2 to be an application of the rationality test.
Yeah.
But that's how I understand the grant of permission, my lady. My lady can take a view. I don't seek to prevent the
No, I
court
understand.
from
Well,
expressing
that's very
a view.
helpful.
And paragraph 46 of Mr Justice Fordham's judgment, sort of reaching the conclusion, he says it follows that no good reason, still less any very good reason, is identified in the decision letter. And that's the basis upon which he reached his decision. And that's what ground 1 is all about, attacking that proposition. So I mean, like my ladies, I'm
not
finding
going
it a
to
bit
advance.
difficult.
I'm not going to advance the point any further. I've made the submission, and the court has expressed it.
But please don't make sure that if there's anything you want to say on that basis, if that's becomes a relevant issue, please do make sure you tell us
Yes. No.
anything you would like to.
As I think my lady understands, our submission is that Mr Justice Fordham was correct on the principle. In any event, his decision on the facts is now academic for the reasons
Right, okay.
outlined,
Okay.
so it will make no difference to where he is placed. But my lady, so
Understood.
far what I've done is I'm seeking to explain by reference to Sneddon what it actually means.
Understand, thank you.
And my submission is that it actually means that questions of evaluation can be questions in which there is a substantial advantage. And what I'm going to do after lunch is to explain why that's consistent.
And would
with
that be a
the-
convenient moment, because we're now starting, as I understand it, the second head of your submissions.
Yes.
Very helpful.
Thank you.
Thank you, Mr Bunting. Are you happy to rise? 2 o'clock is 2 o'clock. 2 o'clock okay for you? 2 o'clock, thank you all.
Just